Well, good morning, everyone. Good afternoon or good evening, wherever you're joining us from. Welcome to our program on the arbitration of cybersecurity breach disputes, with a special focus on such disputes as experienced by lawyers, arbitrators, and law firms. Our esteemed panelists today are members of the Silicon Valley Arbitration Mediation Center. They are Stephanie Cohen, Mark Morrow, Sandra Jeske, Gary Benton, and Sherman Khan. There will be time for audience questions at the end of our program, so please stand by for those. But we'll get started right now with questions for our panelists. Stephanie Cohen, what kinds of cybersecurity breaches are lawyers and arbitrators dealing with at their own law firms?
Well, Jonathan, we read about cybersecurity incidents all the time. So I think the first one is probably not a big shock from what we've been reading in the paper, and that's ransomware. Ransomware is one of the biggest threats that law firms are confronting these days. One of the more prominent examples that was in the news recently involved an entertainment law firm, Grubman Shire, was reported that their computer system was taken over by the Rebel Group, which is a highly sophisticated cyber criminal gang. And they initially demanded $21 million of ransom, but increased it to $42 million when they discovered that they had their hands on files related to Donald Trump. Ultimately, they ended up publishing more than 160 emails relating to Trump, but they were trying to auction off on the internet data belonging to Lady Gaga, Madonna, Bruce Springsteen, Elton John. You name your cast of characters. So that kind of attack is out there. Third-party vendors are another issue that law firms are confronting. Just this past winter, there were a number of law firms who announced data breaches involving third-party vendors that they deal with for file sharing services. So Jones Day, unfortunately, there was a rumor that they had suffered a ransomware attack. They said, no, we didn't suffer a ransomware attack, but we recently learned that our third-party vendor who provides these file sharing services was the subject of a data breach, and that their file transfer platform service was compromised. And it led to the release, among other things, of a judge that had been marked, a brief that had been marked as a confidential mediation brief and a cover letter for various confidential documents. Mm-hmm. A third nature of breaches that law firms have been dealing with are those that result in misdirection of funds. I mean, I think it's no surprise that cyber criminals actually want to make money. So they're looking to monetize what they get their hands on. So when it comes to law firms, that's a really important threat to be aware of. In July of 2020, Holland and Knight, for example, announced, became clear that they were being sued for $3 million, not because of any vulnerability that they experienced with their IT system or anything of that nature, but because they allegedly acted on fraudulent wire instructions. So the classic kind of phishing email where we're not skeptical about instructions that we receive over the internet. I've just given you some examples that come from, I think, fairly high profile and large firms, but it's important to note that this really is not something that is just for big firms to be aware of, or if we're talking just about, those who are handling sort of celebrity files. Real estate lawyers, for example, there have been a number of cases that we've seen reported where they have been in trouble because of acting on, again, those sort of phishing emails. There was a case in 2016 that made its way through the papers quite a bit because the lawyer in question had used an AOL email account. So this is, example of using a consumer level AOL account rather than, an enterprise grade account. And even though it was known that service had been compromised, the lawyer continued to use the service On top of that, her computer had been infested with malware. And as a real estate attorney, there ended up being an issue where she, of course, is handling funds for clients, and someone hacked into her account and successfully perpetrated a $2 million wire theft of her clients' funds. So, I think there are a number of lessons for us there in the nature of those kinds of attacks. But let me also underscore that although I started talking about ransomware with sort of a sensational example, that lawyers are really victim to both the targeted attack and the opportunistic attack. And the targeted attacks are the ones that we tend to read about, right? So that Hollywood example, where there's a successful attack of a Hollywood entertainment firm, that becomes sensationalized, and we all read about it and want to find out what people's confidential secrets are. But more often than not, cyber attacks arise because they're able to, the criminals are able to prey on human error, right? Inadvertent mistakes. So there are a lot of incidents of ransomware that we learn about involving law firms, where it really appears to be the function of run-of-the-mill type issues having arisen. So here's an example. Not of a ransomware, but of a generic kind of hacking. The New York City's law department, 1,000-lawyer agency, got hacked because in July of 2021 by the hackers getting access to a single employee's credentials. And the issue there is that the New York City had actually mandated that two-factor authentication be implemented throughout New York City agencies. And the law department was 2 years behind. So having access to one employee's credentials really enabled the hackers to get access to the law department. We weren't privy to, from public reports what the scope of that attack was, but to prevent further access, the law department had to disable their computer systems and delay court proceedings. So it really had a dramatic effect. And those are a lot of the kinds of stories that we see. And I'll just, end there, by tying it in with the DLA Piper ransomware attack from 2017, because that was another really well-publicized one that reportedly arose from failure to implement a software patch for a known vulnerability. So I think what we see is, there are, ways to sort of target law firms in order to try and monetize the information that's confidential and that, we guard closely, but that a lot of these attacks do arise from opportunity, and it's criminals being able to monetize the information they get because of, human error and failure to implement basic cybersecurity measures.
Thank you. Gary Benton, recognizing that cybersecurity breaches are awfully highly confidential events, do you have any particular eye-popping examples you can add to what Stephanie has just told us about?
Sure, Jonathan. It's hard to follow on to Stephanie. She always has it right. But let me just give a little bit more color to all of this. Cyber attacks occur every 11 seconds. It is a $6 trillion business. And the last 2 years have really been the era, as Stephanie said, the era of ransomware, a ransomware pandemic, quite frankly. Their ransomware attacks have increased 360% from 2019 to 2020, double that most likely this year. Over $1 billion have been demanded just this year alone in ransomware attacks. So when you look at some of these big incidents, we're no longer talking about companies that we've all heard of, like Yahoo and Target and Equifax and MasterCard in terms of breaches. Now it's really come home to hit us. And so in addition to the big breach at DLA that Stephanie mentioned, Jones Day, of course, a lot of other firms this year alone have been hit with attacks, and particularly ransomware attacks. Seaforth Shore, Baker Wotring in Texas, Wood & Woods in Indiana. And it just goes on and on. But there's more to it than that. It's not just law firms being directly hit. What's happening now in cybersecurity is that there are attacks on our vendors, on our suppliers. And so when you look at the big attacks this year and last year alone, those are attacks that have affected law firms as well. So for example, SolarWinds, which was the biggest attack this past year, Russian military spies attacked the Defense Department, Homeland Security, Treasury. But in addition, they attacked 27 US attorneys' offices, and therefore indirectly affecting a lot of the legal profession in that regard. Another example, this past year, the Microsoft Exchange attack, right? There was a flaw in Microsoft Exchange servers, and that has affected many of us who are lawyers relying on Outlook, for example. It put systems down for a while. Another example I'll just throw out is the Acelion attack, the file sharing system that Stephanie mentioned that was used at Jones Day. So these attacks are increasing, and we're going to be seeing more of them.
Let me switch gears a little bit and ask Mark Morrill now. Lawyers and arbitrators have an ethical obligation to guard against cybersecurity breaches. What are the specific ethical rules and requirements that lawyers should bear in mind, Mark?
Thank you, Jonathan. So I will talk about lawyers, I'll talk about arbitrators, and I'll talk about client expectations briefly. Against what we've heard, I think that most lawyers are or should be very interested in just avoiding damage to their own infrastructure and their business relationships. But lawyers have been somewhat behind the curve, at least that's the view of clients that I'll talk about. And lawyers should be aware that on top of their business interests, there really is a very well developed and actually quite granular set of ethical obligations that read directly on cybersecurity. And there's a pretty rich set of resources available to provide guidance. So the basic building blocks of the ethical obligations are found in the ABA model rules of professional conduct that have been adopted by most states. Their model rule 1.1 is a duty of competence. Back in 2012, the ABA added a comment to the duty of competence obligation, comment 8, that says a lawyer should keep abreast of changes in law and its practice, including the benefits and risks associated with relevant technology. Bar associations around the country have weighed in on that. The State Bar of California said that a lawyer has an ethical duty of competence that evolves as new technologies develop and become integrated with the practice of law. There is also, hold on a second. So Model Rule 1.6 is a duty of confidentiality. Again, that has been given a technology color that a lawyer in 2012, that was amended to add that a lawyer shall make reasonable efforts to prevent the inadvertent or unauthorized access to information relating to the representation. There's also a bit of flavor from Model Rule 1.4, which is the duty to keep the client informed. And importantly for lawyers in law firms, Model Rules 5.1 and 5.3, which are duties to supervise lawyers and staff. So from those basic building blocks, there are two seminal ABA formal ethics opinions that address breach-related obligations in a lot of detail. And we can call them before or after or preparation and response. So ABA Formal Opinion 477R from 2017 states that there is a prevention obligation at what it calls the intersection of the lawyer's competence obligation and the confidentiality obligation. That decision holds that lawyers must exercise reasonable efforts to prevent the inadvertent or unauthorized disclosure of information relating to the representation of the client. Now, what constitutes a reasonable effort is not a hard and fast rule. The opinion lists a number of non-exclusive factors that I won't take the time to go into. I would urge that people have at their side these days the ABA Cybersecurity Handbook, which I think now is in its second edition. And that does lay out in pretty fine detail a fact-specific analysis, a risk-based analysis to determining what to do. I think the more interesting opinion is ABA Formal Opinion 483 from 2018. That picks up on where 477R leaves off and addresses the lawyer's obligations when a data breach actually exposes client confidential information. For an ethics opinion, and I did chair the City Bar Ethics Committee, this is surprisingly granular in its advice, I think. So it first defines what is the triggering event. So the one triggering event obviously is where material client confidential information is misappropriated, destroyed, or otherwise compromised. But a triggering event is also where the lawyer's ability to perform legal services is significantly impaired. So that would include your ransomware attacks or anything that destroys or injures the lawyer's infrastructure. The decision lays out in quite a lot of detail the duties that are then triggered. So lawyers have a duty to monitor for data breaches. You cannot relegate the discovery of a data breach to happenstance. You should be monitoring for it. You have a duty to stop the breach and restore systems. The best practice, not mandated, but best practice is to proactively develop an incident response plan that would include specific plans and procedures for responding, identifying a team, eradicating the malware and other factors. There is a duty to investigate, a duty to determine what happened and to provide accurate disclosure to the client about what happened. And then there is, as I said, a notice duty, at least to current clients. It's a bit ambiguous as to whether there's a duty to former clients. The duty includes a duty to notify as to breaches committed by third-party vendors. Both the New York Bar and the California Bar have weighed in on that specifically. And you have to provide the client sufficient information to be able to act. I should note that these ethical obligations do not address the underlying legal obligations. We don't have time to address those today, but the opinions are clear that compliance with the law may not achieve compliance with your ethical obligations, and conversely, compliance with your ethical obligations may not be sufficient for statutes such as the California Consumer Privacy Act, GDPR, HIPAA, and other statutes. There is a lot of material available on that. If anybody wants to email me, I can provide you some resources. Very briefly, Jonathan, you asked about arbitrators. The arbitrators' duties are similar to lawyers' duties, even for non-lawyer arbitrators. Stephanie and I wrote an article called A Call to Cyber Arms in the Fordham International Law Journal, and that goes into that in some detail. I do want to take a few minutes on client expectations. The business clients in recent years have become very aware that law firms are a huge vulnerability for them. Law firms hold some of their most sensitive data. They've historically been less secure than the companies themselves. And it's now pretty common for clients to build cybersecurity expectations into their own terms of engagements and to regularly survey their outside law firms. There is a very interesting document developed in the Sedona conference, which has had a working group on law firm data security and issued a report in 2020 that's easily available online. It starts from the premise that legal and market-based obligations drive companies to ensure that their data that resides with law firms is and remains secure. They note, and I think this is very relevant for this audience, that law firms routinely request to be treated differently from other vendors. They dispose of that very quickly and say, law firms provide an expensive and high margin service. They operate under the same statutes and common law that govern other providers, and there is no basis to treat them differently. I think we all need to consider and absorb that message. So the trend has been that the monitoring of law firm security happens primarily through the corporate law departments. You may also find that the technology groups in companies reach out, as they do with other vendors, and sometimes the compliance organization. The Sedona Working Group advocates questionnaires, and there is a model questionnaire in that document. They also advocate for regular audits on something like a 3-year cycle of outside counsel. And they note that companies may impose very specific requirements, such as complex passwords, encryption requirements, multi-factor authentication. They may want to know about the law firm's training. So I think coming back to where we started, Jonathan, not only do lawyers and law firms need to do this to protect their own interests, but they really have obligations driven by the governing ethical codes and by their client expectations.
All
Thank
very
you.
interesting, very important for us to be completely mindful of. Well, Sandra Jeske, we know that the bad guys are often one step ahead, and we have to act when a breach does occur. Would you please tick off a list of things that the lawyer or arbitrator should attend to when a cybersecurity breach occurs at a law firm?
Yes, thank you, Jonathan. So obviously, the first thing is stop the attack. So that typically involves shutting it down, disconnecting your system, and I would highly advise getting professional help. Oftentimes, you're going to need the log files and different materials to conduct a forensic investigation, and that becomes more difficult if people are looking at things, then they get overwritten. So that's the first thing. And as Mark mentioned, in terms of the ABA Standing Committee on Ethics Formal Opinion 483, it requires the lawyer to act reasonably and promptly to stop the breach and then to mitigate damage resulting from the breach. So that's the first thing, stop the breach. Mark also mentioned an incident response plan, which is typically developed as part of an information security program. So to the extent that you have an incident response plan, you would need to activate that. It'll tell you what steps to take. So that's the next thing. To the extent that you have cyber insurance, just make the call. Typically, the insurer will provide you with panel counsel and typically provide you with a forensic consultant who can engage in an investigation. In connection with the forensic consultant, typically, certainly in the bigger breaches, those things are done typically through outside counsel with an attempt to preserve the reports and the investigation as confidential under work product doctrine or attorney-client privilege, because it will likely reveal some vulnerabilities that had been exploited that presumably should not have been there. Next, you would be involved in the forensic investigation. And that is, number one, make sure that the threat actor, as we call the hacker, is gone, that there isn't any malware that exists in the system. Sometimes there's malware such as advanced persistent threats, or APTs as we call them, where a threat actor can gain unauthorized access to a network and remain undetected for a very long time period, collecting data and just lying in wait before it sends it back. So it's not usually obvious. Often those are state-sponsored attacks. Forensic investigation will typically look at the root cause, or how the attack happened, and attempt to remediate any vulnerability that was associated with that. There'll be an investigation as to whether there was exfiltration of data. And even if there was not exfiltration, typically you'll want to look at whether there was potential access to personal data or sensitive data that was on the systems. And then have to consider, well, what data could have been accessed? And again, that typically involves looking at logs and determining if the threat actor's access was limited to a specific server, if you have more than one server, or a specific data, or more widespread. Oftentimes you can't tell. At the same time, in companion with the forensic investigation, there needs to be a review of, well, what data was actually on the compromised system, and what laws would be implicated by this breach, what contractual obligations exist, and as Mark said, what ethical obligations exist as a companion to that. So let's just tick off each one of those. So the first one that's probably the easiest is contractual obligations. So to the extent that you have maybe an engagement letter or a contract that addresses a security breach or privacy and confidentiality of information, sometimes they will have a set notification period, perhaps 48 hours or something like that. But you would need to look at the contract to see what obligations exist from that. Other notification obligations, well, keep in mind, there's probably two sets of data. We talked a little bit about client data, and we'll get back to that, but you also may have employee data on there as well. And so think of kind of sensitive employee information, social security number or bank account number for direct deposit or healthcare information or something like that. So you would need to look at the state breach notification laws, unfortunately, all of which are different. The key here, I would say, is it depends on what state the employee resides, not where the law firm or the arbitrator sits. So be cautious of that. If it's international, we would need to think about GDPR or any other relevant data protection laws as well. Then you need to think of what notification obligations you have in connection with the clients or the parties involved if you're an arbitrator, and what laws would apply to the data that you hold about them. And so if you have clients or parties involved in regulated industries, HIPAA for healthcare, financial services, GLBA, or perhaps Sarbanes-Oxley, you would need to consider that. You would also need to consider personal data of European persons for GDPR or any other data protection laws, and of course, state breach notification laws as well, involved with the data that you hold of others. As Mark said, there are notification obligations associated with the rules of professional responsibility, as we mentioned, Opinion 483, which addresses a data breach, which again is either material client confidential information that's misappropriated, destroyed, or otherwise compromised, or where a lawyer's ability to perform their services are impaired. And those are very broad terms. Compromise can simply mean data was accessed, because oftentimes you don't actually know if the data was compromised, so to speak. And as Mark said, relies on Rule 1.4 and also 1.1, 1.6, 5.1, and 5.3. So it's important to assess that. The bottom line is that lawyers have a duty to investigate, and they have to disclose information if it's material client information that was actually or reasonably suspected to have accessed, disclosed, or lost in a breach. And the word access is a very big word, which can really take in a lot of activities, even if it wasn't actually exfiltrated. Also, each state may have its own guidance. For example, California State Bar says that you have to resolve all reasonable doubts in favor of client notification. So lawyers have to consult the laws of the various jurisdictions in which they practice and in which the clients do business, because everyone could actually be different and there could be varying interpretations of the lawyer's responsibilities with regard to the data breach. So there's a lot of activities, I think you can tell here, that are occurring all within the same time, where you're looking at contracts, you're looking at data, you're assessing the obligations, you're having a forensic investigation, and then all of that at the end culminates typically with a forensic report and some analysis on what notification obligations have to be done. So several states require that their credit monitoring be provided. Most of the time there's a limit of to how many persons are affected in some of those, but many times, candidly, whether there's an obligation for credit monitoring or not, it's typically provided because information has been compromised, and it's important to protect those whose information has been compromised. Also, there's some thought given to whether or not you're going to maybe say provide credit monitoring for only those states that require it and not for others. And then I think you have to think too about, well, should we treat everyone the same or not, and what impact that may have. So there's a lot of moving parts here and a lot of information that needs to be digested quickly.
Question I have, Sandra, is the number of people within the law firm that would have to be involved. It seems that every lawyer in the firm would have to be aware of its own cases and own vulnerabilities, contractual obligations, sensitive data, et cetera. You're going to need to go lawyer by lawyer, case by case. Isn't that the case?
Well, a lot of times when you have, multiple lawyers or just a large amount of data, you typically will assume that, take the greatest common denominator, in other words. So presume that you have obligations related to the data for each of the clients. Maybe that's an assumption rather than actually going in and actually analyzing the data. Oftentimes it's a real struggle to determine exactly which data was compromised or what obligations exist. And then sometimes the assumption is I could spend, thousands and tens of thousands of dollars trying to figure it out, or I could assume that it has been compromised and just do a broader notification. And so in that case, presumably, if it's a law firm, they would know which clients' data they have, whether that's stored or they're dealing with it, and then maybe make a broader assessment that we assume that it may have been compromised. We aren't sure, but in an abundance of caution, we're providing this notification. And so oftentimes that would be how it would be done, rather than have this broad array of examining every single client and what was on there.
I'm also curious how law firms balance the duty of notification against their own desire to keep things quiet.
That's a difficult thing. So, there are laws that require it. And so sometimes, you have to, you just have to look and see what the law says. Now, if there's, if you're on the fence about whether notification is required under the laws, many of the state breach notification laws actually require you to document the decisions as to how you came to the conclusion that you don't need to notify. And candidly, I would suggest that's a best practice anyway, because as time passes and memories fade or people move on, you may forget. So to the extent that there was a decision made that notification was not necessary under the laws, it is very beneficial to have a memo, even if it wasn't required, so that you can make that determination.
Let me ask Stephanie to add in here. What obligation do lawyers and arbitrators have to notify arbitral institutions of breaches?
So, I think, particularly with the pandemic, we've seen so much more attention being paid by arbitral institutions to issues of cybersecurity and data protection. And one of the things that has resulted from that is that we're actually seeing new rules being implemented that expressly, address this kind of issue. So what the nature of the obligation is kind of like the exercise that Sandy was just talking about, where you have to figure out what laws apply. You have to think about, what rules apply, whose information do I hold in connection with what arbitral institutions, what are their current rules and practices, and then do I have any specific obligations that arise, not just from the general institutional expectation, but practices or agreements that may have been put into place in specific cases. So the ICC, for example, the ICC's current note to parties and counsel requires that, and so this is in the form of guidance on how ICC arbitrations are to be practiced rather than something that's actually in their arbitration rules. But that means that this is the institutional expectation that is put out into the marketplace to parties, to counsel, to arbitrators about how they should act in the event of a breach. That note provides that any breach of the security and confidentiality of personal data, such as unauthorized access to or use of personal data or inadvertent disclosure to persons who should not have been identified as recipients, must be reported immediately to the individual whose personal data may be affected and to the Secretariat. Pursuant to the applicable data protection laws and regulations, ICC, when it acts as data controller, must notify the competent supervisory authority, and as the case may be, the concerned individuals of such breach. So from the ICC's perspective, irrespective of any individual procedures that might have been agreed between the parties, incorporated in a procedural order with the tribunal, regardless of whatever the breach notification obligations may be in that context, the ICC's expectation is that any breach, no limitation as to whether it's material, a material breach or that there was an actual compromise of data, any breach of the security and confidentiality of personal data is supposed to be reported to the ICC. If we turn to the AAA ICDR, another instance where we're sort of looking at guidelines, they have a best practices guide on cybersecurity, so nothing specifically incorporated in their arbitration rules with respect to data breach obligations, but the expectation is that issues of breach detection and notification be discussed at the outset of an arbitration. So you're having a conversation at the initial case management conference, the preliminary hearing, to talk about what the expectations are, and that really can turn on, or should turn ideally on, a discussion that the parties have with respect to the specific information that's going to be involved in the case and what laws they believe would be applicable in the event of a breach, in order to sort of have a more informed discussion about what those breach detection and notification obligations should be. So the sort of item on the checklist that the AAA ICDR asks parties and arbitrators to consider is, will all participants and third parties agree to notify all participants of any security concerns, incidents, or breaches within 24 hours? And that's a question mark. And I think given the complicated matrix that Sandy went through, there's a lot in there. Again, no qualification as to whether it's a material incident, but any incident. So how do we grapple with that? What does that mean? And for sensitive information, the checklist goes on to say breach detection and notification to all parties, the arbitrators, participants, and if applicable, government regulators. Kind of interesting that the AAA ICDR does not ask that they be given notice. Now, obviously, you have to copy an institution whenever you're communicating with the parties and so on, but it's a departure from the way that the ICC has approached this. And I think a lot of this really does stem from their concerns about acting as data controllers and obligations that they have. But this is really where we are right now, the kind of guidance that is out there. In some instances, it's kind of unsatisfactory, I think it's fair to say, because we're left as lawyers, arbitrators, parties to sort of sort through these things ourselves. And And I think Sandy helped us understand this is really quite complicated to figure out what your obligations are in any given instance. So the key point is you have to go back to see what the guidance is, and you know, in cases where there's sensitive data involved, you know, the best practice would be to have a conversation up front and to try and be on the same page about what the expectations are in terms of notification if a breach exists, because you're anticipating that scenario.
Fascinating. Well, Sherman and Gary, let me ask Sherman first. How do cybersecurity claims involving lawyers and arbitrators offices come to arbitration?
Well, of course, like any other matter that comes to arbitration, they come to arbitration because the parties have an agreement that calls for arbitration. And that can come up in a lot of contexts, but it's certainly something that every law firm or lawyer should consider when entering an agreement with somebody that may be may have access to confidential information about the firm, its employees, or its clients, because arbitration can protect to the extent that you don't have a disclosure requirement from under all these various state laws that Sandy brought up, the confidentiality of the relationship and of the problem, and can also certainly enable you to avoid revealing all of the details of the problem. Can also help you to be more flexible about the ways in which the parties cooperate in obtaining resolutions of problems that occur. One aspect of cybersecurity breaches, particularly when they involve various business partners, is that the initial phase of the resolution of the problem is going to require a lot of cooperation. So often the formal arbitration process will happen at a post-cooperative phase when people have finished with the immediate resolution of the problem itself, done the investigation, and then the issue is who has to pay for everything. And arbitration can be very useful for that.
Gary, let me ask you, what kinds of agreements have arbitration clauses that would include claims for harm caused by cybersecurity breaches?
Quite a few, Jonathan. Before I get to that, I just wanted to make one quick comment on the prior discussion regarding prevention and remediation, because some of these numbers are pretty remarkable in that, you know, 1 out of 4 law firms don't have a data breach plan. 1 out of 3 law firms don't have cyber insurance. 1 out of 2 law firms don't have a cyber risk team. And so what that means is when events occur, they often end up being bigger problems than they should be, and resulting in litigations or arbitration. So to answer your question, there's no question the biggest source of claims are claims by law firms against security vendors, the people, the outside providers that you've hired to maintain your systems. And those questions are, for example, did they do the right patches? Did they upgrade? Did they do those patches on time, or did they wait too long? And were the patches done properly? That's the majority of the claims. But there's an increasing risk for many additional types of claims. So for example, really, every vendor that you are relying on for your data that's at risk in the cloud, the data that's at rest in the cloud, data that's at motion in the cloud. So for example, outside providers storing your data, discovery support vendors, document sharing vendors, like in the Jones Day case, All of those are potentially, as Sherman suggested, might have arbitration clauses and could give rise to claims. Financial firms, your accountants, if they have an arbitration clause with you. Co-counsel, when there's a breach, who's responsible if co-counsel on your case? So there may not be an arbitration clause there, but there's certainly going to be some claim and some finger pointing going on. Claims, of course, against insurers for coverage. But here's where we're going to, and it follows on some of the points that Mark made. Your clients, many law firms now have arbitration agreements as part of their engagement letters. When you have a breach, you're bound to see claims from your clients as to the harm that they've suffered. And it gets worse. Here's the worst of it. Your opposing parties and third parties, you enter into a confidentiality agreement in a litigation and arbitration, and you have a breach, you may well find yourself in an arbitration over loss of your opposing counsel, your opposing parties' information. And I can tell you, they're not going to be too friendly about those.
Sherman, what kinds of legal or equitable relief are available in arbitrations involving breaches?
Well, I think that the answer to that is pretty much any of the legal or equitable relief that would be available in a litigation. As I said before, the initial phase of these matters, barring a situation where you have lost your opposing counsel's data, for example, are generally somewhat cooperative. But once you get past that phase and you're into the arbitration phase, the arbitrator would certainly be empowered to fashion equitable relief to ensure that the parties are living up to the contract. If, for example, you have a contract where a business function is outsourced and that has an arbitration agreement, the provider has a security breach, the arbitrator would be empowered and probably able to get into the weeds in a way that a judge wouldn't, to fashion equitable relief to ensure that the vendor remediates the problem properly. And one of the advantages of arbitration is that you can get somebody that actually knows what they're doing with respect to these particular kinds of problems as your arbitrator, and they can really help to make sure that the remedy that is provided is one that will solve the problem so that the particular vulnerability that caused the data breach does not recur. I should add one other thing is remedies in arbitration can be much more effective than in litigation if you have an international relationship. For example, if your data is being held by a company in India or another foreign country that uses has a lot of outsourcing providers or data storage providers. In that case, the New York Convention will enable you to enforce any remedy that you got much more easily than in a litigation, and that's not specific, of course, to these problems, but it's helpful with respect to any international relationship.
Well, with sensitivity to the confidentiality of cybersecurity claims affecting law firms, Sherman, do you have any war stories that may be of particular interest to our audience?
Well, I can actually tell you about something that happened to a firm that's very close to me just a couple of weeks ago. Fortunately, did not involve a law firm. The law firm's data security at all. I mean, it was investigated, and it's not a breach of the law firm, but a client had probably what happened was somebody got into the client's email. A fraudster got information about various invoices from the law firm, and then actually set up a confusingly similar domain to the law firm's domain, used all the lawyers' names, and started sending emails to the client saying to send the payments to a different address. So these things happen, and one thing that you should be careful of as a law firm or a lawyer is that while you have large institutional clients that really take this stuff seriously and are probably more secure than you are, and certainly my firm has clients that are constantly badgering us about where is your data security plan, what are your policies. We want to see them. I mean, because the statistics that Gary just gave are not going to last very long, because the clients are, as Mark pointed out before, insisting that people have those things now. But your firm is going to have not just those large clients, but small individual clients or clients that have 4 or 5 employees, and those clients don't necessarily have the greatest security. So you can find these problems happening from the outside that still affect you as a lawyer, and can be very scary. Fortunately, in the incident I mentioned, it was caught. The fake domain was shut down. Nothing happened, but it's just goes to show you that it comes from every angle, and it's going to happen.
Gary, let me throw in any more stories.
Sure. I have one. Just to follow up first on Sherman's point. Law firms are not among the top 5 industries that are targeted for cyber attacks or ransomware attacks, even. But we're prime targets for it. And Sherman's example of this social engineering, where there's a targeted attack, it really is indicative of how ripe we are for attacks. Because think about it. We publish everything on our websites, all of our victories, all of our losses. And hackers are now smart enough to be going to those websites, looking at them and exploiting them. So there's a real big exposure there. And it's just a feature of the way we do business. In terms of cases, I've had a lot of cybersecurity cases dealing with service vendors. I've only had one that actually involved a law firm, and it's a bit informative. So this was actually a case involving a major law firm, a claim against its security vendor for breach of contract and negligence. And it's interesting to see some of the issues that were involved in that case. So, of course, a big concern was confidentiality. There was a parallel government investigation going on, and the firm involved was very concerned about news getting out. In fact, that was the most surprising thing to me about the case. It never got public, and that's just really surprising to me. Issues in that case, I guess there are 2 that are of particular note. One was who's responsible for the remediation when after the breach occurred. The firm understandably wants to scramble, and cost is no limit to get it to have gotten its system back online, to put their finger in the dike and prevent anything from happening further. And so there was a disagreement in that case between the firm and the vendor as to who was responsible for all of those costs and were they reasonable. Likewise, in that case related to that, there was a limitation of liability provision. And so there was a cap on simply how much could be covered. The case eventually settled. I don't know the outcome beyond that. But again, to me, it was just shocking that despite everything we've talked about the duty to disclose and those obligations, it never made the news.
Following up on what Gary just said, it's really important when you're negotiating these agreements with outside providers that you think about, should we try to get an exception on the limitation of liability for these kinds of incidents? The vendor, of course, will resist that, but you want to think very carefully about the allocation of risk when you're providing data to other parties, and make sure that you can have that risk allocated in a way that both protects your firm and your client as much as possible, but also is consistent with where the insurance may be that will cover these kinds of problems, because sometimes things are really misallocated and it leads to much bigger disputes.
Also, the indemnification clause, as well as the limitation of liability, is a big one. As you currently read them, it's always about claims, and so it wouldn't necessarily cover a breach. So that would be an important point too. Jonathan, is there enough time for me to make another comment?
Absolutely, please.
So one of the things I just want to chat about for a moment is that we all focus on technical safeguards. In other words, this is the IT, we had a hacker come in, our firewall wasn't good. I think of security as a three-legged stool. There's administrative, technical, and physical safeguards. Technical is but one of them. This is not always an IT problem, particularly for law firms. This is, not relegated just there. Administrative safeguards deal with the policies and the procedures and the training and who has access to information, right? You only want to give people access to information that they have a need to know. And so, physical is your paper records and locking the doors to your computer systems and your servers and things of that nature. So there's so much more there just than the technical issues. And as Sherman was talking about, and Gary, about some of the social engineering and things of that nature. So the incident where the emails were attacked that Sherman talked about is phishing. So phishing is because somebody clicked on a link and gave their credentials away. And when that happens, oftentimes the threat actor can get into the system and then elevate the credentials to an administrator level. And now they have access to the entire system. Or you have social engineering, again, which isn't a technical issue. I have had clients in the past who've had very, very complex social engineering things happen. And I'll give you a perfect example that is frankly mind-blowing. It was now a few years ago, but again, it was not a law firm, but it was a professional services firm, and they had a relationship with a national bank. Someone called them pretending to be a representative of the national bank and a new customer service representative. And I want to make sure your needs are met, and I want to establish a relationship with you. I'm going to check in with you every week. We'll review what wires you have going out, and I'll make sure that they happen promptly, this and that. So this relationship goes on for months. All of a sudden they announce that there's new security measures. We need, the head of the organization to fill out this form with their, personal data. They do it thinking again, oh, my bank is taking care of me. And, they continue this discussion about wire transfers. Several wire transfers go through. And when there was a big wire transfer, the money was gone, hundreds of thousands of dollars. The phone number that they had, the email address that they had for this representative, this client service representative, gone. It's all gone. So just don't focus so much. I mean, obviously you want to focus a lot on the technical aspects of it, but my point is that there's so much more than that. Security is not just technical, and you need to be thinking about it holistically from all these different angles. They are out there, they are active, and it really is almost a matter of when, not if.
I actually had somebody personally try to pose as a Citibank representative and do that. And it was incredibly sophisticated, really looked like real Citibank. Mm-hmm. It's very hard sometimes to tell that these things are phishing.
Right. And there are many instances as well where you'll get an email that appears to be one of your vendors or your clients or something telling you that their wire transfer information has changed. Please send it here. I can't tell you how often I've seen that. And you need to pick up the phone and call the person you know and ask if that's accurate. Don't just assume that you got the email, it's accurate. Also, you can hover over the email to see if it looks different, but it's really, really aggressive. And that's why you have to think about it from all these different angles. And if you're big, you have policies and procedures and you train people and you're thinking about it all the time.
I'll just
look
add
up
to
that telephone number independently, not call the telephone number in that email.
Yes.
So,
right. And I was saying the person that you know too. Yes.
Right.
And as a profession, I have to say there's a lot more talk than action. I was astounded. 2 months ago, I attended a cybersecurity program hosted by an institution. And afterwards, I got an email with CLE credit, a PDF, with a link from some third party I had never heard of. And, it just goes to show, I'm sure it was safe. I did go ahead and call the institution and say, who's this coming from? Is this really from you? But that's the thing. There's so much risk out there, so much potential, and you just have to be very, very careful. We were talking too about, just ransomware. The good news on it is that if you do have a ransomware attack, chances are you'll be able to get your data back either through a secure backup somewhere or perhaps by paying the ransom. And 32% of all ransomware attacks, people do pay to get their data back. A lot of times they don't though. And so you want to prevent it before, rather than having to solve the problem afterwards.
Jonathan, I wanted to identify one other party who may be at the table that we haven't discussed, which is the insurance carrier. In many instances, the carrier through subrogation may actually be the real party in interest in these arbitrations. I had one where the vendor was in bankruptcy. Very interesting issue as to whether the automatic stay that was in place as to the vendor should bring a halt to the arbitration. I decided that, first of all, there was a threshold issue as to whether I should decide that or the bankruptcy court should decide that. I decided that I had jurisdiction to decide it. The pot of money from the insurer for the professional services firm that hadn't been breached was available. It wouldn't affect the bankrupt estate. So that went forward. It ultimately settled, but very interesting issues. And I think it is important as you look at the playing field here to remember that the carrier may be a very important factor.
Absolutely. Well, it's time to open up the floor to any questions that the audience might have. I see that Neil Smith has put up a question. Neil, would you like to ask a question? And anybody else who has a question, put up your hand and I'll call on you. Oh, we might have lost Neil. I'll tell you what, I'll read what he wrote on the link here. Typically, neutrals and law firms have old documents from former parties and former clients and disputes, which we retain for a period of time under agreements or custom. If we have to give notice of a data breach, don't these former parties and former clients have to get these notices too? Okay, Mark, that might be a question for you.
Yeah, that issue is directly addressed in the ABA formal opinion 483. The holding of that opinion states that it applies to current clients. And while one could reason to an obligation to prior clients, the ABA committee said that it was not at that time, in the absence of governing law, going to apply that obligation to former clients. It did suggest the best practice of having an agreement with the client at the termination of the matter or the termination of the relationship as to what would happen with the files. I don't think it would be a great leap in logic, given the underlying obligations, to find an obligation to a former client. But the ethical opinions that I'm aware of haven't yet directly held that, but I think there may be some emphasis on the yet.
Mark, that's the ethical side of it, but what about your point earlier about state law disclosure laws, particularly for those like
Absolutely,
California?
absolutely, right.
Yes, that's what I was going to say. I mean, the state laws don't distinguish between some data that's old or not old. It's really what the content of the data is. And if it's certain sensitive information, it will be covered under any of these legal obligations you have for notification. But I think that the question also raises another very interesting point is, you know, at what point does the business need for that data end? And that's why, you know, businesses have document retention policies. You never want to maintain data longer than you actually have a business need to know, because now that data could be at risk. And so, you know, if you're an arbitrator and you don't need the information anymore, then get rid of it. The case is over and it's binding decision, and, you know, or the arbitral institution will have it, but certainly you don't need it anymore. So, you know, to be proactive and to really try to assess whether you truly do have a business need or a legal obligation to maintain that information is something you should be thoughtful about and really limit what information you maintain.
Yeah, this is Neil Smith. I had asked that question, and part of that question related to the retention of information from by arbitrators and mediators where they had things. Sometimes people retain things for use later as forms or whatever, but they have that data. Does the ABA opinion refer to, would that treat former arbitration parties, for example, as clients not having an obligation and be interpreted that way? Or are our clients, are our arbitration parties that we arbitrate for, our agreements often say they're not treated as clients, but do we have a greater or lesser obligation to them in retaining their data and giving notice?
Neil, you're correct in making the distinction as to arbitrators. Most of the ethical rules, and this is addressed in some detail in the Fordham article that Stephanie and I wrote, most of the legal obligations really are in the context of lawyer-client obligations. So it takes some reasoning to get to the obligations of an arbitrator. It's discussed in some detail in the Fordham article. And the obligations are there, but again, not as directly as they're stated in respect to client obligations. But again, there's a, you know, there can be a confluence of legal obligations and ethical obligations, whether you're talking about a current relationship or a historical relationship.
But there's also, I think, an important practical point, which is, you know, put aside what your ethical or legal obligations are to give notice. If information is compromised, if we hold sensitive information that's compromised, whether it's from an arbitration 20 years ago as an arbitrator, 5 years ago, 6 months ago, or a current arbitration, there's a reputational impact of that information being disclosed. And if it's through a failure to implement reasonable security measures, we're holding on to data for 20 years when there's no longer a business need for it. That doesn't look good. That does not help us in our practice as arbitrators. I think it goes back to Sandy's sort of point is, you know, do you need the information? As an arbitrator, I think some of the things that we can do are, you know, one, I have to hold on to some information about, you know, parties and experts and so on in a conflicts database. I'm going to keep the names of the parties in that spreadsheet. That is information I need to hold on to. I personally like to hold on to a copy of my award in a case. But then for other things, if there are documents, Neil, you said you want to rely on from case to case, you can make an anonymized version of that Word document. You don't need to hold on to, you know, an original PDF version. You can take, you know, a Word document and you can sanitize it and keep clauses that you use. in sort of, a more generic document that you pull together from different pieces. So there are a lot of things that we can do to make sure that we don't hold on to that data. And I think in a worst case scenario, and I wouldn't say that this is like an ideal practice, but if you don't have time to manage your data and there's a delay between when you are able to go through and destroy stuff and keep on top of it, you don't have to keep it, in your current files. You could move that in, onto a hard drive or something that you could, manage a month from now when you have time to be able to go through and eliminate the documents that you don't need. We don't have to keep it in our cloud. We can archive things. So there are lots of steps we can do to try and minimize the access and potential for breach of the sensitive data.
One of my favorite maxims is actually from Stephanie, which is, you cannot lose what you don't have.
That's a great piece of wisdom to carry around.
Right.
Now, does anyone else have a question? We're getting short on time here. Panel members or people in the audience, any further questions?
I'll ask all of you if I can. So this actually comes from a real life example. Your law firm is hacked. You decide to pay $4 million to get your data back. Who's responsible for that $4 million? The insurers, your service provider? Do you bear that risk?
I don't have $4 million, so it's a moot point.
Let's say you did.
I would argue not to pay. So I would have a lot of arguments about not paying. It's because they're bad guys. You're dealing with criminals. You can't trust them not to do anything with your data, and it certainly doesn't avoid your obligations that you already have. And certainly the FBI tells you shouldn't be paying. So my argument would be, are you not paying? But anyway, so that's a different answer than what you were asking.
No, they're all good answers. And
the recovery percentages on ransom are very low.
Yeah.
Yes. I mean, I know that the insurers will sometimes work with you. I personally have worked with, now they have basically hostage negotiators who negotiate with the threat actors. And so I have seen instances where the insurer will pay for that activity. And sometimes it's really a matter of getting an understanding as to what they really have, seeking proof of life, as you will, in terms of the data. Sometimes it's about negotiating, but I personally haven't seen it paid, but I know that they will participate in that, but that's an insurer decision if you have insurance.
Excellent. Well, we are out of time now. I want to thank all of the panelists this afternoon and everybody who attended in the audience. And thanks also to our sponsor, the Silicon Valley Arbitration and Mediation Center. Good afternoon, good evening to all. Thank you.
Thank you.
Thank you, Jonathan.
Thank you.